Section 20 of Hindu Adoption and Maintenance Act provides maintenance towards aged and infirm parents also for children and unmarried daughters. So regarding that, the liability to maintain aged, old and infirm parents who are unable to maintain themselves out of their own property and earnings has been imposed upon the sons and daughters. The term parents include adoptive father, adoptive mother, and a childless stepmother, but does not include grandparents and the stepfather. The words unable to maintain include both physical and financial inability. It is a personal liability on the part of the sons and daughters to maintain their aged, old, and infirm parents. So also, regarding children, the parents are liable to maintain their minor children. It includes both legitimate and illegitimate children. The children on acquiring majority or capacity to maintain themselves brings their liability to an end. Further, unmarried daughters can claim maintenance subject to the condition that they are unable to maintain themselves by own separate earnings and property. When a daughter becomes widow without having any earnings and property out of her deceased husband, can also claim maintenance from her parents. So, regarding that, we will discuss certain leading cases. One of them is Musambi versus Sahaji Mangal Lal in 1961. The Rajasthan High Court held that maintenance of parents rests on the condition that such parents are aged, old, or infirm and unable to maintain out of their own earnings or property. And the second important leading case related to this, Wali Ram Varian Singh versus Srimati Mukhityar Kaur, and it was a case of 1969, and the decision was delivered by the Punjab High Court, where it was expressed that refusal of parents to provide maintenance to unmarried daughter that she is able to maintain herself, the burden of proof rests with such parents. And the next important leading case is Chandra Kishore versus Nanak Chand 1975. The Delhi High Court held that a Hindu is obliged not only to provide day-to-day expenses of his or her unmarried daughter, but also her reasonable marriage expenses. And the next leading case is Tulsi Kumar Anil Kumar versus Raghavan Nair, a case of 1985. The Kerala High Court held that the agreement between the husband and the wife that the mother will maintain the child does not take away the right of the child from claiming maintenance from the father. And the next important leading case is Krishna Prasad Rao versus Jayasri 1986, the decision was delivered by Andhra Pradesh High Court, where it was held the liability of the parents to maintain their children is absolute, so no preconditions can be forced on the children. And the last important leading case relating to Section 20 of the Hindu Adoption and Maintenance Act 1956 is Pikkurangapve versus Pikkar Chinnaha. In 1970, the Andhra Pradesh High Court held that liability of a stepson to maintain his stepmother arises only if that son gets some share in the property of his father. So, this is all about Section 20 of Hindu Adoption and Maintenance Act of 1956, which provides maintenance to the old, aged, infirm parents. So also the children, here means the minor children and unmarried daughters. So this is all about maintenance as per the provisions of Section 20 of Hindu Adoption and Maintenance Act 1956.